the record, Cameron Wood, Office of Legislative Counsel. Quick note of pride for me. It's my first time in this committee in this role. However, I started my career in Vermont as an intern during my last semester of law school with Michelle Childs. So I did spend some time in this committee 11 years ago. I'm not from Vermont, I'm from Alabama. I learned what a scone was in this committee. So just a little point of note for me. So happy to be here. Mr. Chair, would you like me to share the language? I think you all have it. So.
Yeah, if you don't mind, if you're still watching.
Okay. Give me just a brief moment then to get started. If you don't mind sharing the link for me, that would be perfect. So okay, I'll just start with a little background then as I'm trying to pull this up. This started as a standalone House bill, as you mentioned, H169. It was introduced in the House. It is in House General. And the language that you have here is slightly different than the bill that was introduced. The bill that was introduced would add citizenship and immigration status into the protected classes for both public accommodations and unfair housing practices. So that's the primary, length of the bill. That's why it's 7 pages. It's because it will be going in and adding those two, citizenship and immigration status, into each of those subdivisions under unfair housing practices and in public accommodations. The bill as introduced also included a prohibition on requesting Social Security numbers, landlords. It would prohibit landlords from requesting a Social Security number on a rental application. The part of that language was included in S-127, which is the housing bill that the Senate passed. As the housing bill was in Senate Economic Development, they incorporated parts of 169, specifically the parts of prohibiting discrimination, public accommodation, and unfair housing practices. They did not incorporate the prohibition on requesting Social Security number. As this was in the Senate, Senate Economic Development Committee, there was some concern that was raised about that language, and so they made tweaks to it before it was passed. And now I'm able to share my screen. Okay. I'm going to skip over section 1 for right now, because I'm going to come back to it. Sections 2, 3, and 4, as I mentioned, adding citizenship, immigration status into public accommodations, unfair housing practices. When you get down to one of the provisions in the unfair housing practices, subdivision 6 specifically says that an individual cannot discriminate against any person in the making or purchasing of loans or providing other financial assistance for real estate related transactions or in the selling, brokering, appraising of residential real property, etc. When this provision was in Senate Economic Development initially in the housing bill S-147, so there was concern raised by financial institutions about that subdivision in particular. Federal law allows financial institutions to take into account someone's immigration status when making determinations of whether to issue out loans or not. They calculate it into the risk associated with an individual in that determination. So there was some concern from banking institutions about including immigration status specifically. So the Senate removed that from the unfair housing practices section in your housing bill. So the housing bill that Senate passed, 127, includes citizenship and immigration status protections in public accommodations, but only included citizenship status in unfair housing practices. Okay, then it went to the House. S-127 is in House General, and since they received that bill, they have been discussing these provisions, because again, it's standalone H-169 sitting on their wall, and then they have portions of it in the Senate housing bill that they've been reviewing. Right? So, in testifying and going through with witnesses and working through with the committee, that's why you have this document. And that's why it's drafted as orphan language as a possible amendment to 169. What the House did was they ended up incorporating this into their proposed amendment to your housing bill. Okay. So Senate Economic Development is now working through their proposed amendment to the housing bill that they received from the House. And the question is whether to incorporate this language into their bill. So that's the context, okay? And again, I'm going to come back to section 1. I just get us down to what I was just discussing, citizenship and immigration status and housing. You have these subdivision 2 and a subdivision E, which is being added to the unfair housing practices piece. There were 2 primary concerns that were raised or have been raised. I mentioned one of them, the financial institutions and their ability to take into account someone's immigration status and issuing out loans. And federal law specifically allows them to do that. So subdivision E was drafted. I worked with my counterpart Maria Royal in our office to draft this subsection E, which says for the purposes of that subdivision, it shall not constitute unlawful discrimination for a lender to consider a credit applicant's immigration status to the extent such status has a bearing on the lender's rights and remedies regarding loan repayment.
Whose responsibility is it to show that it has a bearing on the rights and remedies regarding loan repayment and further provide loan?
Yeah, so as I see this working out, it would be an individual believes that they've been discriminated against by a bank or a financial institution. They would then make a complaint with the Human Rights Commission first. And then the bank or financial institution would then need to show that they're asking for immigration status or the policy that they have meets this subdivision, and they're asking for it, or they're not unlawfully discriminating against someone because they're considering the immigration status to the extent that they're weighing whether or not to give someone a loan. So it's really going to be fact dependent on what the bank is doing. The cases that I've read, because there are some protections under federal law for these types of arguments, and I can go. We can deep dive into that to the extent that you all would like me to. The cases that I've seen so far that have an argument under federal law are banks that simply don't allow you to even submit an application unless you're a citizen or unless you have a social security number. And so there have been certain cases, primarily DACA recipients or individuals that are protected or here in this country due to DACA. They were bringing cases under federal law against those institutions saying they were being discriminated against because they may have a co-signer who is a citizen, or they simply can't even submit the application. And the financial institutions in those instances were claiming under federal law they have the ability to take into account immigration status and making determinations on whether to issue credit. And courts are saying, but you're not even allowing them to submit the application. So your policy is potentially a violation of federal law. That's a very roundabout way. I don't know if I answered your question directly, and I apologize if I didn't.
And that's okay. There may not be an answer because I think, to your point, so many of these things are fact dependent. I just always worry when the burden of proof falls on the person claiming discrimination and not the person saying, no, I'm not discriminating.
Yeah, my understanding is the individual is going to have to show that there is discrimination against them, either, on its face, the policy is discriminatory, or there's some sort of discriminatory, disparate impact to them as an individual. If they're able to make that showing, then the financial institution or the bank would have to come in and show that their policy or specifically the practice to that individual is not discriminatory. And the reason the committee wanted to add this is because they didn't want there to be a conflict between state and federal law. Federal law specifically authorizes a financial institution to take into account your immigration status and whether issuing credit. And without a similar provision, what you could have is you could have a financial institution that's denying someone individually a loan because they're taking into account, you're only here on a student visa and, your visa expires in 12 months. We don't want to issue you a mortgage. And if you don't have a similar provision, somebody brings a case against that financial institution and they're saying, but I'm authorized to take this into account under federal law. And then it becomes a question of how the state is going to interpret its state law if you don't have similar provisions.
I think yeah.
Well, so my question is, because I know that there are some areas where we as a state are able to be more protective than federal law and other areas where that's not necessarily true. And I'm not familiar enough with the banking laws to know if that's an area where we can be more protective.
So I think in this area, public accommodations and unfair housing, you as a state generally, you're able to be more protected. We have more protected classes in our public accommodations and unfair housing practices than exist at the federal level. So you're able to be more protective. The concern and the issue that I was raising with the committee is you don't want to put yourself in a position where you're asking individuals to potentially be in direct conflict with federal law. So if we say as a state, you can't discriminate against somebody in giving out loans because of their immigration status, and the Human Rights Commission and the court determine that to mean something much more stringent than what's at federal law, you're going to have banks that are going to be in conflict and they're going to raise preemption challenges. They're going to say federal law specifically authorizes us to do this, not requires us, but it allows us to do it. And you state, by not giving us that similar authorization, you're putting us at risk. And if somebody brings a claim against us, my point to you all would be, if I were that attorney at that financial institution, I would be arguing preemption. That because federal banking laws specifically authorize banks to do it, that your state can't prohibit it. And I would just be concerned if you don't have a similar provision there, it's just bringing the entire protection scheme into question.
Curious. I can't. I'm fairly confident national origin is considered a suspect classification. How? And I imagine it's been litigated already, but how does that federal law meet strict scrutiny when they're talking about authorizing that for people based on citizenship or immigration status, which in my mind I'm connecting to national origin?
I'm going to try my best to give a description of what I found at the federal level. And I apologize if I need to come back and answer some of your questions. I wasn't aware I was coming in here until a few moments ago. There are two federal laws at play. One of them is 42 USC 1981, and it specifically protects and says that that individuals shall have, the same rights as white citizens in making and enforcing contracts. Federal law, federal courts have interpreted that to mean when it says individuals have the same rights as white citizens, that applies to aliens as well as naturalized citizens.
Are you saying white citizens?
That is what the statute says, yes, sir. Because it was drafted immediately after the 14th Amendment, and I believe it started in the 1860s. It was then amended, I believe, in the 1870s. And yes, that is what the language still says. That's crazy.
Yeah, the language certainly tells a story.
Yeah. Okay. 42 USC 1981. All persons within the jurisdiction of the United States shall have the same right in every state to make and enforce contracts as is enjoyed by white citizens. And so this is about making and enforcing contracts, and understand that a mortgage or a loan is a contract. So you have this. Separate from this, you also have, I believe it's the Equal Credit Opportunity Act, and I can pull that up as well if you want, but that is the law that prohibits discrimination in the making of loans and mortgages and issuance of credit to insert your list of classes. National origin is one of them. That is also the statute that specifically authorizes those banks to take into account someone's immigration status when determining whether to issue credit. What I haven't found is I haven't found any Let me back up. So again, under this law, the courts have said that this includes or is also a protection of individuals, aliens who are here. And I'm trying my best to use language that the courts use. I've said this in every committee I've been in, so please forgive me if I'm not using language that some individuals would prefer that I use. I'm trying my best to follow what the courts are saying. Again, this statute applies to aliens. There is a question about whether or not this protection would extend to individuals who are here unlawfully. That's an open question. I've seen some court cases that specifically attach the word lawfully to this. And so presuming that individuals who are not here lawfully would not enjoy this protection or would not be able to make a claim under this law.
It does say all persons within the jurisdiction.
I agree. I just haven't seen that
Yeah.
argument specifically made in a court make that holding. Other things that I haven't seen is when you look at, again, as I mentioned, the Equal Credit Opportunity Act, you know, with the federal fair housing, they use national origin. I haven't seen courts read into national origin immigration status. So what I've seen is you would have to make an argument that you are being discriminated based on your national origin being, you know, pick something versus making an argument that you're being discriminated against your immigration status. And when I was initially doing the research and I spoke with the lead sponsor of the House bill, I kind of talked to her about that. Open question for me, if you're discriminating against someone and they make a claim you're discriminating against me because of my national origin being Latin American or from a Latin American country, and I turn around and say, no, I'm not, I'm discriminating against you because you're an illegal alien. I don't know whether a court is going to read or allow that case to go forward if you're how they would just, you know, how they are going to distinguish those two, whether they're going to make that as no, that's just a pretext and you're actually discriminating against someone because of their national origin or not. Trying to circle all the way around to your question, Mr. Chair. This specifically comes up because of, again, the Equal Credit Opportunity Act, which I can try to bring up as well. But that law in particular specifically authorizes financial institutions to do this. And I haven't seen a case where someone's arguing that that provision of the law is unconstitutional because it somehow doesn't pass strict scrutiny in that sense.
I'm thinking about the due process clause, which also says cannot deprive any person, just like here, it's any person.
Correct.
So whether somebody is here legally or not, they're entitled to due process. Yes.
One would make that argument, and we are seeing
Would one be correct in your opinion?
this is not my area of expertise. I'm being careful because the president of the United States and his administration is arguing the opposite.
Yeah.
So I'm trying to be careful here for those two
How
reasons.
about pre-Trump? Wasn't the understanding in the case law that it's any person is within the jurisdiction of the US is
I want to defer to my judiciary colleagues on that.
okay. Because as I read the language of the statute that you put out, it does speak to this bill and to the additions to it in an affirming way. Sits comfortably with my reading of that federal statute.
Still bring a case against that financial institution claiming discrimination under the law that we just looked at. It's just going to be a fact specific scenario.
Yeah.
Again, are you denying every loan to every individual who is an alien that's here lawfully because you don't want to loan to people that are here lawfully? There was a memo that actually came out. If you wanted to, I could try to find it and pull it up. A few years ago, I think it was in 2023, there was a memo that came out from the what is it? It was the U.S. Department of Justice and the one of the credit bureaus, and it was reminding banks that potentially blanket discrimination against aliens who are here lawfully in issuance of credit could violate that provision. And so the concern, though, was, again, as I mentioned earlier, putting your financial institutions here in Vermont somehow in conflict with complying with state versus federal law. If federal law allows them to take it into account, and without similar language in this bill, if you don't have that and you just say discrimination against immigration status is a violation of our laws, it opens them up to potential lawsuits from individuals for complying with federal laws.
But on page 6, it seems like we cover that base. Down 14.4.
Yes, sir. No, I agree with you. Yes, sir.
Yeah.
There in the subsection E, and that's why the House General Committee wanted that language in.
Yeah.
So,
But the federal law is a may, not a shall. So if federal law allows something that in other spaces doesn't mean the state can't disallow it. But if federal law says you shall do something and we disallow it, then we run into conflict in a different way.
I think this is how I share it with House General. This is a policy decision for you all. You all can say, despite the fact that federal law authorizes you to do this, we're not going to put a similar provision in the subsection E. And then it's just going to become an open question. Someone potentially could make a complaint to the Human Rights Commission against the bank. And then at that point, the Human Rights Commission and the courts are going to determine whether asking about immigration status on an application is going to be a violation of state law. And my comments to the committee were, if I'm the counsel for the financial institution, I'm going to make an argument that that is preempted. A court's going to then make that determination. I agree with you, Senator. It's federal law authorizes it. I think you all could say, great, we don't want to authorize it. It's not a requirement, it's a may, and we don't think that you should. And my point is simply, I think that is going to open up the state to a preemption argument, and it's potentially going to be struck down. I can't guarantee that. That's what I would be arguing if I were counsel on the other side.
Okay.
As I'm trying to find that memo, forgive me. I am not, so I'm just going to keep talking about the bill. The other provision in here is this subsection D. There are specific federal programs that authorize or require that funds for housing go to individuals that are here lawfully. So your Section 8 housing vouchers, etc. There are federal provisions within those statutory sections that state that the funds cannot be provided to individuals who are here unlawfully. And there was concern about what the Trump administration might do in the housing context. Currently, there is no prohibition on renting to individuals who are here unlawfully. And the question from the committee was, well, what happens if the federal government imposes said restriction? And so the House General Committee wanted this language, this subsection D inserted, which says, if required by federal law, verification of immigration status, that's where it started. Not the highlighted language. It started with, if required by federal law, verification of immigration status shall not constitute a violation of subsection A. Again, there are certain federal dollars that require them to go to somebody who's here lawfully. That was where that provision started. And then they added or differential treatment on the basis of citizenship or immigration status. So if it's required by federal law, differential treatment on the basis of citizenship or immigration status will not constitute a violation of subsection A. Again, it's not required now, but there was concern among the committee members about what could happen in the future. And so that is why this subsection was included.
Do you have questions?
I did, and it's a little bit out of our jurisdiction, but it is coming up as we talk about this and the protections we're talking about under current law. There is no, under current state law, you can rent someone regardless of immigration status. Are those individuals provided all the same rights and protections under our housing policy? Does my question make sense?
Yes, and I think that's probably a question best for the Human Rights Commission. I don't know, I haven't found any case in Vermont that would indicate otherwise. So I think,
The
yes.
state housing and the protections around deposits being returned and all of that
Yes.
extends. Okay.
Yes. Yes.
Okay, thanks. So I certainly know we've heard some pretty awful cases of people, migrant workers being rented really subpar.
Right.
Rentals, and would want to make sure that they are protected.
Yes, I would have to pull up those sections, but no, I don't think. No, those, prohibitions and requirements apply to the landlord irrespective of who they're renting those locations to. And so that is the primary piece of the bill related to public accommodation and unfair housing practices. Again, a question in the Senate Economic Development Committee is whether to include this in our housing bill. It would add these two classifications into those protections, include these two, subsection caveats. The other piece is at the very beginning, where, if you recall, I mentioned that part of 169 initially included a prohibition on landlords from requesting a social security number to do a background check or a credit check. The committee took a lot of testimony and found out you're not required to have a social security number to do a background or a credit check. It's potentially more effective to do it that way. And so the committee landed on this language, which is in the, currently it's a section related to rental application fees. So we're kind of striking two provisions there and having the section just be residential rental applications. So the new subsection A, which is current language in law, that says that landlords cannot charge an application fee in order to submit a rental application. This would add a subsection B, which would state that in order to conduct a background or credit check, a landlord shall accept any of the following. And then it would be either an original or a copy of an unexpired form of government issued identification, an individual taxpayer identification number. So there are individuals who are here in the country, that can get an individual taxpayer identification number if they're not eligible to get a social security number so they can file their taxes. Or a social security number. So you have to accept any of those following. And then the committee wanting to, ensure that that was hopefully playing out in real life for individuals. And so they wanted the rental applications to inform applicants of that requirement. And so, how I read these things going together, this subsection B, along with including immigration status into the unfair housing practices, is if you're a landlord and you, for example, only allow people, or you will only rent to people who provide you with a social security number, I think you're opening yourself up to a complaint of somebody saying, I don't have a social security number. You have a blanket prohibition on renting to people without one. That's a discrimination based on my immigration status. I think that would be a successful argument one could make. It doesn't prohibit the landlord from asking for one, but if you don't have one, the landlord, if they're needing to do a background check or credit check, would have to take these other forms as well. Question came up at Senate Economic Development about, well, what if somebody doesn't have credit or, a credit history? And I was telling them that I don't see anything in this language that would prohibit a landlord from saying, if you do not have minimum credit of X, I will not rent to you. And again, as long as they're accepting these forms of identification, they're not excluding people without a social, which you don't have to have a social to do a credit check. So like, those are the fact specific arguments that you're gonna get into when you include these provisions or when they go to the Human Rights Commission, et cetera.
Way that I read B1 being a shall would mean that the individual applying for tenancy provides one of these and the landlord shall accept it, not say, oh, I don't want this, I want a different thing.
Correct.
Okay.
That is, it was drafted with that thought in mind. Yes.
Any further questions or comments about this? Okay. Well, we don't have it technically in our committee to vote on, but I suppose, are we generally supportive, unsupportive, neutral?
Generally.
Support.
Yeah, I'm just,
Housing.
yeah, I'm curious about unlawfully being here. The landlord has no way of knowing based on this.
What do you mean exactly?
Like immigration status, unlawfully being here, the landlord would have no way of knowing based on this if someone's here unlawfully or applying for it.
I think if this were to go into law.
Mm.
And you as a landlord began to verify immigration status for the purpose of not renting to individuals who are here unlawfully. I think that an argument could be made to the Human Rights Commission, to the court, that you are discriminating against someone. That's where I just can't assure you all whether a court is going to extend the protection to someone who's here unlawfully. I don't know. This gets back to the conversation we were having about the process.
Yeah.
I think arguments can be made that they do apply. You know, it's a prohibition against discrimination against, trying to grab the language here, persons. I'm looking at our statute now. You know, so I think that an argument could be made that it does. Unless there is, and that's why they added the subsection D there, maybe federal law changes and says you have to verify, you can only rent to people that are here lawfully. And at that point, the landlord's going to be protected by validating immigration status at the point of renting. I will say other concerns came up in the context of potentially landlords harboring individuals who are here unlawfully. So there's specific federal law that makes it a crime to harbor unlawful individuals. I mentioned to the Senate Economic Development Committee and mentioned it here. Multiple circuit courts have found that the mere act of renting to someone is not itself harboring an individual such that it's a violation of federal law. So circling all the way back to answer your question, without anything else, if this language as it's presented in front of you were to go into law in Vermont, I think that an individual could make an argument that if you are excluding unlawful individuals,
yes,
that you are violating immigration status. Whether the Human Rights Commission and a court would then extend the protection to those people, I can't guarantee that. And that'd be, I would start with the Human Rights Commission, how they've interpreted. They may have cases that they've already interpreted that, and I just haven't found them.
Just as a quick follow-up to what you said, if I'm understanding it correctly, I think in terms of landlord liability, if this is to go into law and the landlord can't become aware of immigration status, in my general opinion, I think that would, and based on what our counsel just said, I think that would shield them to some extent from what the federal law is in terms of harboring. Because you can't know as a result of state law, and you're not being some of the elements for that, for whatever the federal violated, I think, but it's just my general opinion.
And just very quickly, I would say again, the circuits that have made determinations on this require there to be something in addition to simply renting to someone. If you're, so the protection here, if you're a landlord and you're concerned, well, you've added this to state law now. I have to rent to somebody who's potentially here unlawfully because I don't want to run afoul of state law. I have concerns about how that may put me in breaking federal law or breaking.
And what was that federal law, by the way?
It is 8 USC 1324. So these are criminal penalties related to bringing individuals into the country unlawfully, and then specifically there is says any person who knowingly or in reckless disregard of the fact that an alien has come to enter or remain in the United States in violation of the law conceals, harbors, or shields from detection such alien. So these are federal criminal laws against, again, harboring people, bringing people in illegally, et cetera. The courts have said though, so the third, fifth, eighth circuits state that harboring encompasses conduct that tends to substantially facilitate non-citizens remaining and prevents authorities from detecting non-citizens. The second, seventh, and ninth, we're in the second circuit, have opinion that harboring requires a defendant to act intentionally or purposefully. So simply renting to somebody without you doing additional steps to try to prevent their detection from federal authorities, courts have said doesn't rise to the level of that criminal offense.
Even though the federal law contains the knowingly standard, wouldn't the most protective be for at the state level for really everyone, landlord, the tenant, just be a prohibition on asking about immigration status? Because if you don't know.
Yes, I mean, I think that's going to be a defense for you as a landlord, right? I didn't ask.
There's also reckless disregard in there as well.
It's knowing or reckless disregard of the fact.
But if you don't know, you can't
Yes.
recklessly disregard it.
Well, I think there are arguments that you could, depending on what the facts are, but I mean, those are hypotheticals. I just wanted to make sure I knew that it was knowingly and reckless, but yeah. Any other questions or comments? All right. Well, thank you.
You're welcome.
Appreciate it.
Well, up to you.